to ask.
Hello, Your Honor.
All right. Do you guys have a case number for Mr. Caraballo? I don't have one on my end.
Judge, I believe this was an arrest warrant that was signed yesterday.
Yep, correct. All right. Good morning, sir. Can you tell me your name?
My name, sir, is Albert Caraballo.
Mr. Caraballo, you are here on, we'll call it agency number 21-9462 for arrest warrant signed by myself with charges of aggravated battery on a pregnant person, domestic violence, and burglary of an unoccupied conveyance. Probable cause has been determined in this case. Is there a victim by any chance?
What was the third one? I didn't hear you, sir.
First charge, aggravated battery on a pregnant person, domestic violence. Second charge is burglary of conveyance.
And the other one?
Burglary of a conveyance.
What is that?
I'm going to have one appointed public defender to represent you in this case. She can explain to you what those charges are in a moment. However, anybody have any other domestic violence history for Mr. Caraballo?
No, Judge, he does not. His last conviction was 2018, and that was for notice to appear for possession of cannabis and paraphernalia. He doesn't have any domestic violence history whatsoever. Also, there was no contact ordered on the conditions of warrant, and there was no victim info attached.
Okay. And he doesn't qualify for a pretrial release, correct?
No, Judge.
All right. All right, sir. I'm going to set your bond in count 1 in amount of $5,000. Count 2, I'm going to stay your bond at $3,500. Condition your bond, you have no contact with the victim in this case. You need to make sure you're maintaining a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I already appointed a public defender to represent you in this case. Do you have any questions about your no contact order, sir?
I have a question. If she decides to drop these charges.
No. Answer my question. Do you have questions about the no contact order?
Okay.
So I'm saying, make sure, I'm going to be clear with you. No, zero, absolutely no contact. No carrier pigeon, no writing letters in the sky, billboards, social media, anything you could think about would be contact with this victim through a third party is going to get you arrested. That goes for everybody else in that room. That means the warrants will be sent to me. You're going to be set at no bond. You'll be hanging out at the Osceola County Jail until somebody has an opportunity to deal with your case. You understand?
What if there's a daughter involved?
No contact.
Okay, sir.
I want to be clear. So this is going to be crystal with everybody. No contact. Zero. Absolutely zero contact until a black robe and somebody looks like me, I wish you could see me, tells you that you can have contact. You understand that?
Yes, Your Honor.
All right. Yes, ma'am.
Do you want me to go down the way the charges are written?
What is the burglary conveyance?
They have on the front sheet burglary unoccupied vehicle unarmed.
Yeah, the conveyance vehicle, same thing.
So you want me to change it to this burglary or leave it?
Yeah, it's fine. The verbiage is fine.
Okay.
Because vehicle and conveyance are synonymous.
Okay.
All right. Have a great day, sir. All right.
Thank you, Your Honor.
I got Calavan. Am I saying that right?
Call him. I believe it's Shannon.
Yeah. I'm going to make sure I'm not saying this last name correctly. I'm quite sure.
How we doing, Your Honor?
Doing well. Can you tell me your name, sir?
Michael Colhane.
What happened to Shannon?
Oh, I'm sorry, Your Honor. I thought you said Colhane and not Kavanaugh.
No. Well, sorry, Mr. Cohen is already there. We'll come back to Mr. Cohen. You are here for a violation of probation in case 2021 CT 930. Bond, your violation of probation warrant is no bond. Your bond's going to remain as set. I'm going to appoint the public defender to represent you in this case. You have a great day, sir.
Yes, sir.
All right. Have a great day, sir. Have a seat, sir. All right. Is it Cavani?
Kavanaugh.
Kavanaugh.
Shannon?
I'm sorry. Sorry for butchering the name. Can you tell me your name, ma'am?
Yeah, it's Shannon Kavanaugh.
All right, Ms. Kavanaugh, you are here for a few of Bay County warrants.
Yeah.
The case numbers I have in the first case is 23726B, charges of fraudulent personal use of personal identification. You also have 23726C for uttering of forgery and 23726A for theft. And they want me to set bonds here for her, but I don't have any history or any information. I don't have a face sheet for her.
Judge, we don't do any out-of-county histories.
Yeah, that's fine, but if the judge wants me to set, they ordered it on the warrant says set bond at IAs.
So does
And
that
she's
mean
not
that
charged
we
with a
can
capital
get-
offense. Say, do you have any history?
Allow me a moment, Your Honor. I'll check. There's some battery cases from Pinellas County that are closed, but that's 17 CF 2404. And some other misdemeanor and traffic infraction from Pinellas County.
Any theft related cases?
There's a petty theft from Pinellas County 19 MM 1944, which is also closed.
All right, Ms. Kavanaugh, in 23726B, I'm going to set your bond in that case an amount of $2,000. In addition to that bond, that you had no contact with the victim. You do not possess any personal identification except your own. In 23726C, in your uttering case, I'm going to set your bond amount of $1,000. In addition to bond, no contact with the victim in that case. In 23726A, going to set your bond in that case an amount of $1,500. Condition your bond that you have no contact with the victim and not return to the scene of the incident where that theft occurred. All right, you have a great day, ma'am.
Thank you.
Hello, Leah. Am I saying that correct? Good morning, sir. Can you tell me your name?
My name is Ed Loyola, sir.
Say your last name again.
Loyola.
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 So, Loyola, you're here. We'll call it Osceola County Sheriff's Case 2021 I-1231921 on charge of battery domestic violence. They reviewed the charging affidavit in your case. It did find probable cause for your arrest.
Judge, if I may.
Go ahead.
The defendant does not have any criminal history, and he's a great candidate for bond with pretrial release. We did speak with the victim, and she's requesting him to come home and to have contact. She was unable to come to court because she has 2 small children.
Okay. All right. Well, until I can get some sworn testimony from her, I'll grant your request. I'm going to set bond in the amount of $500. I'm going to come with pretrial release supervision. They have no contact with the victim in this case. We're going to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I'm going to appoint the public defender to represent you in this matter until your wife is able to get to court some way, somehow, and provide sworn testimony to another judge in a bond hearing. You're to have no contact with the victim. Do you understand, sir?
Yes, I do, sir.
All right. Have a great day. All right. I had Carlos Lopez.
Judge, can we wait to the end? We should have 2 victims that.
They're here. I'm looking at them right now.
Thank you, Judge.
No problem. All right. Good morning, sir. Can you tell me your name?
Carlos Lopez.
Mr. Lopez, you are here in Osceola County Sheriff's Case 2021 I-122812 on a arrest affidavit charging kidnapping, aggravated battery with a deadly weapon, burglary with assault with battery therein, aggravated assault with a deadly weapon, and 2 counts of battery, possession of a weapon or ammunition by a convicted felon, and resisting officer without violence. I did review the charging affidavit in this case, and I did find probable cause for your arrest as to these charges. I'm going to start from my right to my left. Ma'am, can you tell me your name and say your last name? Spell your last name.
Tamalin Diaz, D-I-A-Z.
All right. And can you raise your right hand to be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Ma'am, can you tell me how you know Mr. Lopez?
He's my husband.
And do you want to have contact with him while this case is pending?
So due to DCF, I'm not allowed.
Okay.
So I don't have a problem with the contact because we have a son together.
Okay.
But unfortunately, they don't want him to be there due to the kids.
All right. Did drugs or alcohol play a role in this incident?
Alcohol.
Okay. And has there been previous instances of domestic violence between you all in the past?
No, sir.
All right. All right. Can you step back and, ma'am, can you step up? Can you tell me your name and spell your last name?
Jennifer Lopez, L-O-P-E-Z, Lopez.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down, ma'am. Can you tell me how you know Mr. Carlos Lopez?
He's my father.
And do you want to have contact with him while this case is pending?
Yes, sir.
Has there been previous instances of domestic violence between you all in the past?
No, sir.
Well, since you were an adult.
No, sir. No.
Okay. All right, State, do you have any questions for these 2 witnesses?
Not at this time, Your Honor.
I want to appoint a public defender to represent you, Mr. Lopez. Do you have any questions for the 2 witnesses, ma'am?
No, sir.
Yes, Your Honor. I'd like to get clarity on what DCF has stated to the alleged victim about contact. Since there seems to be minor children involved, I'd like to know if the court would entertain no hostile contact, depending on what DCF has already determined.
So, to my understanding, he is allowed to have contact with our children. Somebody has to be there, I'm assuming, and he has to contact. But she said she would know more once today happened. So it was very limited. They just asked questions, and they said for right now, he wasn't allowed to come back home. But no hostile contact. she said if that's what you guys assigned, then it would be fine.
Your Honor, in light of that information, defense would request no hostile contact with a third party in regards to the children.
All right. So what about the facts of this case
Can I speak, Judge?
contend that the court should grant your request?
I'm sorry, Your Honor?
What about the facts of his history and this case say that the court and this should be wise to give no hostile contact to these victims in this case?
Given the testimony of the victims and the fact that there hasn't been other domestic history previously and the small children, defense would request that, given the children didn't seem to have been present during this and would probably like their father involved. That's why defense would request that the court would honor.
All right. So I'm looking at a face sheet that, I'm correct, PTR, that lists a prior domestic violence history, correct?
Yes, Mr. Lopez, the domestic violence happened in 2009. That was the last domestic violence. Whether it's with the same victim or not, we were unable to confirm. The majority of the last 2 years, 3 years, hey, hold on, is a habitual duelist. Driving while license is suspended, revoked. He's currently out on bond in Marion County. And that was in December of last year. So within the last 7 years, Judge, he's only had 2 arrests, and both of them are habitual driving while license is suspended. His last conviction is 2018.
Your Honor.
Kentucky.
Am I allowed?
Yes, ma'am.
Carlos Lopez did 10 years. So he got out. We don't have any history of violence. What he did was horrible. He was intoxicated due to him serving 10 years, him having many times of being in the hole, 18 months max alone. He does have issues. We have fixed the court that he has now. He was going to work. He was actually just putting gas in the car for his boss. He shouldn't have done it. It wasn't okay. They told us if we paid all of the fines, he got his license, then he would not have to serve any time and the case would have been dropped. So we did all of that. We paid $6,000 and more. Unfortunately, because he's a habitual offender, they denied that. And so he does have to serve his 60 days, which he's going to do. He was supposed to do January.
Oh, I'm sorry. Can you guys mute it out there? Because I got a lot of feedback. Press the mute button for me, please. There you go. Thank you. Sorry, I couldn't. He's been trying to fix his life, Your Honor. If you look, he's an amazing father. The burglary is not true. The kidnapping, it was never unforced. A lot of those charges there, I don't even know why they're there. I know that it was a bad situation, but he needs. It wasn't him, and please don't let his past history affect him because he did 10 years for it, and we've been doing so hard trying to fix everything. He did make a mistake. It was a big mistake. But he shouldn't have to do extra time for it. I'll never see him again if you don't punish him, please. Well, ma'am, I'm not the judge that's going to determine whether he's guilty or not of these allegations. It's going to be up to the state of Florida whether they're going to file all of these charges or whether what they can prove out of these things to a jury beyond a reasonable doubt. My job in this case is to provide release conditions if possible. He's not to anybody. One of those conditions is one of the charges that he's facing is count 1 is a life felony. So I'm going to ask the state of Florida what do they think, what are they asking the court to do as it relates to that charge. Okay. So state, what are you asking that the court do as to count 1 of the information in this charging affidavit?
After listening to the victim's testimony and everything that's been presented this morning, the state was still required the first count to be a no bond based solely on the facts of this case and what happened that day. The victim is stating that it was a mistake and all of that, but for her safety, for her family's safety, we're requesting a no bond.
All right. And counsel.
Yes, Your Honor.
Sorry, so Mr. I did appoint a public defender to represent you. What is your response to the state's request?
While we understand.
And are you asking to have an Arthur hearing at this moment?
Your Honor, we wouldn't ask for an Arthur hearing at this point. We would just ask the court to consider the alleged victim's testimony, and that she doesn't feel in danger and she would like contact with the alleged victim, and the fact that the defendant's previous history is mostly non-violent, and the last violent issue was almost 20 years ago.
Yeah.
Ma'am, like I said, I don't have to have contact with him if you don't want him to see the kids, but he's not a threat. He really isn't. I know what you're saying. I know that he was intoxicated and he needs mental help, but you guys putting him back in prison is not helping him. He really needs to get psychological help. And Medicaid is denied because I make too much money. So the help that we're trying to receive, so we're married now. I'm waiting for my insurance to add him on because we've only been married 6 months. So we're trying to do everything. So I will follow anything you want, but I don't feel like the no bond is necessary. He can go to his mother's house. She's really far from me, all the way in Lake County. And again, I don't feel like he should have to be in prison. I feel like this should be time that he should be seeking medical help to prove his case when the trial comes. Please.
All right, ma'am. He's entitled to what they call an Arthur hearing or a bond hearing in front of the division judge. Right now, I don't have enough information. I have your testimony, what you're telling me, and I have the four corners of the affidavit that's in front of me. There are other things that can be presented at that hearing when that happens that may move the judge to determine whether proof evidence presumption great and whether that the bond is going to be held at no bond under our Florida Constitution. But until that happens, what I'm going to do is to count one is hold him at no bond. In count two, I'm going to set bond an amount of $15,000. Count three, state, are you asking for the same thing?
Yes, Your Honor.
At count three, I'm going to hold him at no bond. Count four, I'm going to set bond an amount of $5,000. Count 1, 2, 3, 4, 5, and 6. I'm going to set bond amount of $500 each. Count 7, I'm going to set bond amount of $5,000, and count 8, I'm going to set bond in amount of $100. Condition on the bond until a judge like me in the black robe tells him he's to have no contact with you or any victim in this case. He's not to have contact with any witnesses from this case. He is not to return to the location where this incident occurred. He is to not possess any weapons or firearms. Any weapons or firearms he has needs to be turned over to law enforcement within 24 hours of his release. And I already appointed the public defender to represent him in this case. Also, he's not allowed to possess or consume any drugs or alcohol without a valid prescription. He's going to be subject to random drug and alcohol testing when he's out on release in this case. Now, this is not the end of the road. It's just the beginning. Like I explained to you, once this case moves forward, we can see what the state of Florida decides to do because they control the navigation of where the case is going to go and whether these charges are going to be filed or not filed. That's completely up to those. But right now, I can't overlook the level of violence inside of this case. And the potential danger to everyone that was involved, including your children and the people inside the house that was being shot at. So I can't overlook that right
Nobody
now.
was shot at in the house.
If I remember this is the case. Sorry.
I don't know that like I said, the charges on there are.
I don't know. When it's like the report, they got a report that shots were being fired, that there was evidence that shots were fired. I don't know if there was a gun found inside the vehicle from which that he was arrested in. Mm-hmm. All things that don't bode well in my wisdom, to give him contact or release him right now. Hopefully he can get some help. It's like from the Osceola County Jail, for some of the mental health programs they have there at that location, and maybe find some diagnosis that is going to help him move forward. But until that happens, there's going to be no contact, and the order's going to remain as set. All right. All right. Everybody have a great day.
Thank you.
All right. Next person I have is Robertson. Good morning, sir. Can you tell me your name?
My name is Dexter Robertson.
Mr. Robertson, you're here in Call it KPD case 2021-9456. I'm charged trespass on property after warning. I did review the charging affidavit. In this case, I did find probable cause for your arrest. Are you guys resolving cases out there in Osceola this morning? Or
We have,
Yeah.
the- we have the ability to do so, Your Honor, but I would need a moment to confer with the defendant if that's what he wants to do.
all right. Not sure why bond is set at no bond on this trespass case.
Judge,
And well, another question, he's out on bond cases. It seems like he's on conditional release. He's not been found incompetent to proceed in those other cases.
we are not quite sure,
Yes,
Judge.
I was almost CRD. That's probably what I'm saying. No bond.
Judge, he was released on the 22nd
From prison.
from prison.
I had 2
and
months.
So you're on parole.
he's on a conditional release. His parole ends, I believe, January
All right.
of next year.
All right, sir, since that's the case, I'm going to set your bond in this case in an amount of $500, condition the bond that you not return to the scene of the location where this incident occurred, not have any contact with any victims or witnesses from this case. We may be hearing from the parole board sooner than later.
Judge, are you going to take no action?
I'm going to appoint the public defender to represent you. That's what I'm trying to figure out. Is he out on bond in these other cases, or he was released? I see a 2020 case where he's on conditional release, but he has the 2019 cases.
He was actually sentenced on both of them at the same time, Judge.
Yeah, so if he's on conditional release from
On both of
parole, on all of them, of course, I don't have any jurisdiction to take any action on his cases because that's a executive situation between him and the parole board, and not a judge thing. If he's on probation, then yes, but
Right.
both cases, I guess he's on conditional release.
Thank you, Judge.
Conditional.
Yeah, he's on conditional release on parole, whatever you want to call it here. All right, I have Joshua Ruff. All right, good morning, sir. Can you tell me your name?
Joshua Ruff.
All right, this is St. Cloud case 2021-5669. Mr. Ruff, there's been a warrant signed for your arrest for charges. Oh, sorry. Oops. Sorry, I apologize. The affidavit for your arrest for charge of criminal mischief in 2021 MM 3083. And in that warrant, the judge found probable cause. I don't have the warrant affidavit. And set your bond in the amount of $500. Condition of your bond, sir, is that you are to not return to the scene of the location and have no contact with victims or witnesses from this case. I'm going to appoint the public defender to represent you in this matter. You have a great day, sir.
Yes, sir.
Next person. All right. I'll keep this one. So the next person I have is Edgar Willis.
Edgar?
Willis. Fall asleep.
He's approaching, Your Honor.
There you go. Good morning, sir. Can you tell me your name?
Edgar Willis.
Mr. Willis, you're here in 2021 CT 2389 for a failure to appear warrant. Bond in your case is $2,000. Your bond's going to remain as set. Is the public defender already appointed in this case?
We're not sure, Your Honor, but I did have him sign an affidavit.
All right, I'll appoint the public defender to represent him if he's not already appointed. All right. And I think, other than our interpreter cases, that's it, correct?
Yes, Your Honor.
He called me, so he's here.
Okay. All right, let's add him on there.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have not been sworn today, Your Honor.
All right. Good morning, Mr. Barrera. Again, can you raise your right hand to be sworn in? Do you solemnly swear you will translate from English to Spanish and Spanish to English to the best of your ability, so help you God?
I do, Your Honor.
All right. I am here with the Osceola County connection. My first case I need to call is Danny Fernandez. And he should be approaching the lectern here.
Yes, Your Honor, he is approaching.
And do we have a case number yet, Your Honor? Or
I don't believe, yes. It's 2021 MM502W.
Thank you, Your Honor.
All right. Good morning, sir. Can you tell me your name?
Buenos días, caballero. Por favor, dígame su nombre despacio en voz alta.
Good morning, Danny Fernandez.
Danny Fernandez.
Mr. Fernandez, you're here for an out-of-county warrant from Orange County in 2021 MM502.
Señor Fernández, usted está aquí mediante una orden de arresto que proviene del condado de Orange en el caso 21 MM502.
Bond on your warrant is $1,000. It's going to remain as set.
La fianza programada son $1,000. Va a permanecer tal como está.
I'm going to order that you not have any contact with any victims or witnesses and not return to the scene of the location where this theft occurred.
No se le permitirá tener contacto con la presunta víctima o testigos y no puede regresar al lugar de los acontecimientos.
I'm going to appoint the public defender to represent you. You have a great day, sir.
Le voy a asignar las oficinas al defensor público para que los represente. Que tenga buen día, caballero.
¿Puedo decir algo?
Can I say something?
You have the right to remain silent during this matter. I suggest you exercise that right at this moment.
Y usted tiene el derecho a permanecer en silencio durante este asunto. Le sugiero que lo haga.
Have a great day, sir.
Que tenga buen día, caballero.
All right. All right, and next I have is Mr. Mejias.
My apologies, Your Honor. Could you kindly confirm the name of this defendant?
It's Alfredo Mejias Sanes. I'm going to maybe say that right. Sanes. I don't think I have a case number for him.
No worries, Your Honor. Thank you for confirming the name.
All right, good morning, sir. Can you tell me your name?
Buenos días, caballero. Por favor, dígame su nombre.
Alfredo Mejía.
Alfredo Mejías.
Mr. Mejias, you're here in an Osceola County arrest 2021-123-172 on charge of providing false information or identification by an arrestee and resisting officer without violence.
Señor Mejía, usted está aquí en el arresto 21-123-172 por darle información falsa a un oficial del orden público y resistir su arresto sin violencia.
I reviewed the warrant, the charging affidavit in this case. It did find probable cause for those two arrests. Going to state your bonds and $500 on each count.
He revisado el affidavit de arresto, determino que existe motivo fundado y voy a programar su fianza en $500 en cada cargo.
I'm going to appoint the public defender to represent you.
Voy a asignar las oficinas del defensor público para que lo representen.
And you have a great day, sir.
Que tenga buen día, caballero. Thank you.
All right. The next person I have is Annabelle Pino Morales. Or Annabelle Pino Morales.
He's approaching, Your Honor.
Good morning, sir. Can you tell me your name?
Buenos días, caballero. Por favor, dígame su nombre.
Buenos días, Aníbal Pino Morales.
Good
morning,
here
Aníbal Pino Morales.
in Kissimmee Police Department arrest 2021-9483 on charge of possession of cocaine and possession of drug paraphernalia.
Señor, usted fue arrestado en el arresto del departamento de Kissimmee 219-483 por posesión de cocaína, posesión de parafernalia de drogas.
I did review the charging affidavit in your case. I did find probable cause for your arrest.
Revisé el documento acusatorio y determino que existe motivo fundado para su arresto.
I'm going to release you on pretrial release in this case. Conditions of your pretrial release that you did not possess or consume any drugs or alcohol without a valid prescription, and you'll be subject to RAM drug testing.
Le voy a dar su libertad bajo el programa de libertad prejuicial con condiciones de que no ingiera o posea alcohol o drogas ilícitas o cualquier medicamento que no sea que tenga receta y pruebas de orina al azar.
You're not to associate yourself with any known drug dealers or drug users.
No se puede asociar usted con vendedores de drogas o usuarios de drogas.
I'm going to appoint the public defender to represent you in this case. You have a great day, sir.
Le voy a asignar a las oficinas del defensor público que lo representen en este caso. Que tengamos buen día, caballero. Thank you.
All right. Did I miss anybody?
No, Your Honor.
All right. All right. Thank you, Mr. Barrera. I may have to call you back in a moment.
Yes, Your Honor. Thank you.
All right. All right. Does anybody have anything else? Make sure anybody has anything else before the court before we sign off in Osceola?
Just verify, Your Honor, would you like to start early again tomorrow as well?
It really depends. I only had 2 juvenile cases this morning, and then there was only, how many cases from Osceola? We got 20, is that?
We'll be here if you decide to, so thank you very much.
Yeah, we can start earlier. I mean, we can get you guys on to Sunday dinner earlier.
All right, perfect. Thank you, Your Honor. We'll see you tomorrow.
All right. Have a great day.